And we have with us for today, from the Institute of Law of the Far Eastern University in Makati, we have Dean Melencio Santa Maria, Jr. Good morning, sirs. And we also have Dr. Jeremy Gatdula. No, I'm sorry. We also have Professor Edmond Tayao, the Executive Director of the Local Government Development Foundation. That's it for now, Your Honor.
And a member, Professor Tayo, member of the Constitutional Commission, sir, no? Professor, yes. Okay, so we will acknowledge the other resource persons we have invited who will arrive later. So at this point, let us hear from the author of proposed Senate Resolution number 305, Senator Drilon.
Thank you very much, Mr. Chairman. And at the outset, let me acknowledge my appreciation to the committee for including in the agenda our proposed Senate Resolution number 305, which proposes to present a sense of the Senate resolution which basically would assert the role of the Senate in the area of foreign relations. Mr. Chairman, the President has recently made two important decisions insofar as the treaties are concerned. The President terminated the membership or the adherence of the country to the Rome Statute, and more recently the bilateral agreement between the U.S. and the Philippines. This is the Visiting Forces Agreement. The issue, therefore, is the participation of the Senate in this process of termination. As we talk today, there appears to be none. And that is why we thought that we should have the sense of the Senate resolution. And for the record, the Senate President has manifested his intention, even publicly, to bring this issue to the Supreme Court on a petition for declaratory relief, which will asking the Supreme Court to clearly define the constitutional boundaries of the shared power between the executive branch and the legislative branch insofar as treaty making is concerned. The specific issue that will be brought to the Supreme Court on a declaratory relief is whether or not the President possesses a general, sweeping, unilateral blanket authority to terminate a treaty whose ratification was concurred by the Philippine Senate. And our submission is that that power is not unilateral. It is a power that is shared by the Senate. It is true that treaty withdrawal power is not in our Constitution. It is not in our Constitution. It is only treaty making, but treaty withdrawal is not in our Constitution. However, the legal scholars in the United States has put forward the theory that we should apply the mirror principle. What is the mirror principle? It simply says that the degree of congressional participation constitutionally required to exit any particular agreement should mirror the degree of congressional participation that is required to enter into the agreement in the first place. In other words, what the mirror principle states is that the process in withdrawal should follow the same process in accession to the treaty. That's why it mirrors the procedure. Now, in our Senate, Mr. Chairman, as you are aware, we have already ratified about 20 treaties, which includes a provision that any withdrawal should have the concurrence of the Senate. We recall the climate change agreement. It was specific, and that's. Can I have my telephone with? The climate change agreement, wherein it was very specific that the withdrawal, to be effective, must have the concurrence of 2/3, and several other treaties. Hold on, I have my notes. No, in the, okay. Resolution number 42, concurring in the accession to the Paris Agreement. This is on March 14, 2017. The resolution read, resolved finally that the President of the Philippines may, with the concurrence of 2/3 of the members of the Senate, withdraw from the agreement. The same substance of a condition was in the Articles of Agreement on the Asian Infrastructure Bank. That we concurred in. And if my memory serves me right, there are about 20 other treaties containing this same condition. And that is why our submission is that the concurrence of the Senate should be required before a withdrawal can be made effective. We must not forget that a treaty entered into by the government, where the concurrence is ratified by the Senate, or where the ratification is concurred in by the Senate, it becomes part of the law of the land, and in fact becomes the source of many domestic laws. And for example, the avoidance of double taxation is a treaty. Now, this was ratified by the Senate. If it is unilaterally terminated, what happens to the tax credits that those who are favorably affected by this? The other thing, there's a treaty on exchange of prisoners signed by the Philippines and Spain, under which the national of each country may serve their prison sentences in each other's jurisdiction. Under our jurisdiction, service of sentence must be done in the Philippines. But the treaty on the exchange of prisoners that we had with Spain allowed the service of sentence in Spain for Spanish citizens. That is why one of those convicted in the Chong case is Larissa is serving sentence in Spain, and the service there is credited as service done in our penal system. Our agreements on Social Security, which allows our OFWs to enjoy retirement benefits from Social Security systems abroad, where they are a member. Most important, UNCLOS. We are a signatory to the UNCLOS, and on the basis of our being a member of UNCLOS and having signed the Convention of the Law, a convention of the National Convention of the Sea, by virtue of Resolution 121, the UNCLOS became the very basis of our entitlement to a 200 nautical mile exclusive economic zone. If we withdraw from this without unilaterally, what happens now? Now, I am citing this in order to emphasize that a unilateral determination has a lot as as a number of policy implications. And Congress, being the primary policymaker in our system of government, must have a say in determination because this involves policy issues. And it is, I am saying that we should participate when a treaty is terminated. And therefore, we have presented this proposed Senate Resolution number 305, and we hope that we can clarify and assert the role of the Senate in termination of treaties, and it should not be, and we cannot accept the proposition that this is the sole prerogative of the President. We would want, through a petition for declaratory relief, be brought this to the Supreme Court so that the Supreme Court can define the constitutional boundaries between the two political organs of this government. Thank you very much, Mr. President.
Thank you, Senator De Alonso. We welcome also Senator Gordon. Thank you, and Father Aquino, Ranilio Aquino. Sorry. So, can we start hearing from our resource persons? We should start with, I think, with the Department of Foreign Affairs, the Office of Treaties and Legal Affairs, Assistant Secretary Bailen, whom we have requested way back in February 6 to already study the resolution. No? So I hope you're now ready to present your position on the subject matter. So you have the floor, Assistant Secretary Bailen.
Thank you, Mr. Chairman. Good morning. First of all, the Department of Foreign Affairs fully appreciates the spirit and rationale behind Senate Resolution 305 filed by the Honorable Senator Franklin Rilon. Your Honors, pursuant to the President's instruction and in accordance with Article 9 of the Visiting Forces Agreement, the Department of Foreign Affairs sent the notice of termination to the U.S. Embassy on 11 February 2020. Said termination shall become effective 180 days after or on 9 August this year. In this regard, and in view of Resolution number 305, the Department of Foreign Affairs proffers the following position. First, the President is the singular voice and authority of the country in foreign relations. The President of the Philippines, being the head of state, is regarded as the sole organ and authority in external relations and is the country's sole representative with foreign nations. Wielding vast powers and influence, his conduct in the external affairs of the nation is, quote-unquote, executive altogether. To quote the Supreme Court in the case of Sagisag versus Executive Secretary, the conduct of foreign relations is full of complexities and consequences, sometimes with life and death significance to the nation, especially in times of war. It can only be entrusted to that department of government which can act on the basis of the best available information and can decide with decisiveness. It is also the President who possesses the most comprehensive and most confidential information about foreign countries, for our diplomatic and consular officials regularly brief him on meaningful events all over the world. He has also unlimited access to ultra-sensitive military intelligence data. In fine, the presidential role in foreign affairs is dominant, and the President is traditionally accorded a wider degree of discretion in the conduct of foreign affairs. The regularity, nay validity of his actions is adjudged under less stringent standards, lest their judicial repudiation lead to breach of an international obligation, rupture of state relations, breach of an international forfeiture of confidence, national embarrassment, and a plethora of other problems with equally undesirable consequences, end quote. Although some provisions of the Constitution limit this power, clearly the power to defend the state and to act as its representative in the international sphere inheres in the person of the President as the incarnation of the Republic. Second, the role of the Senate in the treaty process is to give or withhold its consent or to concur in the President's ratification. The Constitution contains two provisions requiring the concurrence of the Senate in the presidential ratification on treaties. The first is Article 7, Section 21, which lays down the general rule on treaties or international agreements. This provision applies to a variety of treaties and requires the concurrence of 2/3 of all the members of the Senate. The second is Article 18, Section 25, which is a special concurrence clause designed for a category of treaties, namely those which have to do with foreign military bases, troops, and facilities. The participation of the Senate in the treaty-making process is designed to provide a check on the executive in the field of foreign relations. By requiring the concurrence of the Senate in the treaties entered into by the President, the Constitution ensures a healthy system of checks and balances necessary in the nation's pursuit of political maturity and growth. This participation, however, is limited to giving or withholding the consent or concurrence in the ratification. As held in the case of Pimentel versus Executive Secretary, and I quote, "It should be emphasized that under our Constitution, the power to ratify is vested in the President, subject to the concurrence of the Senate. The role of the Senate, however, is limited only to giving or withholding its consent or concurrence to the ratification," unquote. Thus, in terms of entering into a treaty, both the Constitution and jurisprudence are clear that the role of the Senate is limited only in this sense. Third, the power to enter into a treaty, such as the Visiting Forces Agreement, and to terminate the same, falls within the constitutional power of the President. The President's prerogative and plenary power as the chief architect of the nation's foreign policy has long been acknowledged sacrosanct as a constitutional cornerstone. When the VFA was ratified in 1998, the Supreme Court upheld this power to it, and I quote, "As regards the power to enter into treaties or international agreements, the Constitution vests the same in the President, subject only to the concurrence of at least 2/3 vote of all the members of the Senate." In this light, the negotiation of the VFA and the subsequent ratification of the agreement are exclusive acts which pertain solely to the President in the lawful exercise of his vast executive and diplomatic powers granted him no less than by the fundamental law itself. Into the field of negotiation, the Senate cannot intrude, and Congress itself is powerless to invade it. Consequently, the acts or judgment calls of the President involving the VFA, specifically the acts of ratification and entering into a treaty, and those necessary or incidental to the exercise of such principal acts, squarely fall within the sphere of his constitutional powers. When President Duterte sent the VFA notice of termination, he was merely exercising his diplomatic powers granted to him by the Constitution. As the power to enter into treaties is vested in the President, the power to terminate the same is incidental or residual thereto. Finally, the termination of the VFA does not require the concurrence of the Senate. A plain reading of Section 21, Article 7 of the Constitution merely requires the concurrence of at least 2/3 of all the members of the Senate to make a treaty binding on the country. Were the framers of the Constitution of a different intention, they would have specifically and expressly provided for the necessity for a similar concurrence by the Senate in the termination of or withdrawal from a treaty. To interpret otherwise would be repugnant to the principle of verba legis, and as mentioned above, the role of the Senate is limited only to giving or withdrawing its consent or concurrence in the ratification. Neither requirement of concurrence or withdrawal exists in Section 21, Article 7, or Section 25 of Article 18 of the Constitution. The Department is prepared to engage with the Senate on moving forward on this constitutional question. Mr. Chairman, this position paper has earlier been officially conveyed to your office yesterday. Thank you, Mr. Chairman.
Thank you, ASEC Valenzuela. Let's now hear from the second resource person to arrive, Dean Santa Maria of the Institute of Law, FU. And thank you, ASEC Bailen, for keeping your presentation below 10 minutes. So I don't know if the Dean can also do that. But if should the written position paper be longer, you can just submit to us the position paper. Okay? Thank you, sir. Go ahead, Dean.
Good morning, ladies and gentlemen, honorable senators. Abuse of right. The right may be clear, but that right can be abused. And I think that's the very essence of the shared competency of the legislature and the executive department in matters on treaty making and treaty withdrawal. Prior to the September 1991 RP-US military bases agreements abrogation, our people were divided as to its propriety. But we were comforted by the fact that those officials who sought its end were intelligently rational, not disposed to acting whimsically and capriciously, and not subservient to then President Corazon Aquino, who wanted the bases to stay. Led by the brilliant Senate President Vito Salonga, 11 other senators approved the abrogation after much Senate studies, discussion, debates, and public hearings. Moreover, the US-Soviet Union Cold War was ending at the time. There was no use for the US military bases here. And I am sure that shrewd and intelligent as he was, Senator Salonga considered this global eventuality. By December 1991, the Soviet Union collapsed. Eventually, the Filipino people embraced the termination, realizing its soundness and Salonga's accurate foresight. Now, in the midst of China's aggressiveness in the West Philippine Sea, threatening regional security, and I would say even land grabbing some of our islands, even installing missiles in some of them, and notwithstanding our inadequate military capability, President Duterte, as we heard in these hearings, without prior consultation with foreign DFA Secretary Locsin, and probably also not utilizing the DFA's expertise, decided to end the RP-US Visiting Forces Agreement. It was his response against the US being, quote-unquote, bastos, in interfering with Senator De Lima's incarceration and in prohibiting those responsible from going to the United States. Canceling the VFA requires not a myopic, knee-jerk decision, but a response resulting from a circumspect analysis intrinsically of its content and extrinsically of the rewards or non-benefit from the same. First, let's look at the content. The VFA, among other, mandates respect for Philippine laws, exemption from visa requirement of U.S. military personnel during their temporary sojourn in the Philippines, jurisdiction for violation of our criminal laws, our government's prior approval of U.S. ships' Philippine entry, exemption from port dues, waiver of claims by each country for damages caused by the VFA's implementation, but not with respect to contract and or non-combatant activities, and waiver of import duties relative to reasonable personal effects of U.S. military personnel. If the Philippine government does not want to implement the tax-free exemptions and free port duties, it can simply disallow the U.S. ships from docking in our local piers, not allowing in turn entry of U.S. personnel, and therefore not triggering the application of the tax waivers. And also, there is nothing to prevent the Philippines from renegotiating the agreement. Second, The BFA, alongside the Mutual Defense Treaty and the Enhanced Defense Cooperation Agreement with the U.S., have provided the Philippines an assurance of U.S. military assistance in case of outside aggression and or of natural calamities, knowledge of modern military combat techniques, and also financial assistance amounting to hundreds of millions of dollars for the Philippine Armed Forces modernization. If our government properly invoked them after the West Philippine Sea Comprehensive Victory at The Hague, I believe, it's my personal view, the Chinese arrogance could have been restrained. Overall, there is nothing earth-shakingly evil in the VFA detrimental to our national interest. Alliances are not bad. Asia-Pacific countries cannot match China militarily. But the clear strategy is this. With the U.S. siding with them, China's military adventurism can be forestalled. Consequently, they can use more money for their businesses with less military spending. Their economies grow, and yet without endangering their regional security position. A common sense strategy perplexingly shunned, it seems to me, by President Duterte as exhibited by the VFA's termination. This is not to say that without the BFA we will not prosper. Having the BFA is simply being smart. Significantly, Singapore allows the U.S. Navy and Air Force to use the Sembawang-based facility since 1992 for the U.S. 7th Fleet. South Korea and Japan permit U.S. military base presence. Vietnam, the USS's former enemy, has welcomed U.S. naval forces visits since 2007. Malaysia and the U.S. engage in cooperative military training and joint exercises. Though the U.S. established diplomatic relations with Beijing, it provides Taiwan substantial military equipment and weapons. These countries' economies are further prospering, their security improving. Surely the BFA can be abrogated, but it must be done in accordance with the spirit of the Constitution, and not at this time. The termination notice to the U.S. can still be withdrawn. It will be best, as far as I'm concerned, to wait for the right people to make the right decision for the right reasons at the right time. Just like what Senator Jovito Salonga and the other now called Magnificent 11 senators historically did in 1991. And also, I do not think Filipinos who see the usefulness of a Philippine-U.S. military arrangement are less patriotic than Filipinos who object to it. 84% of Filipinos in a latest Pulse Asia survey trust the U.S. more than any country, especially China. And so the question is, was the VFA termination policy at this time against the people's interests? I believe so. Indeed, there is a thin line between foolishness and bravery, stupidity and shrewdness, impetuousness and presence of mind. Which do you think amply characterize this government's policy? The important question also is this: was the unilateral termination by the Executive Department of the BFA illegal and a rude affront to the authority and majesty of this august body, the Senate? I submit it is. Both the power to conclude treaties and the power to terminate it form part of the treaty-making power of the state. And in the Philippine Constitution, our people even generically and made such shared competency applicable to international agreements. There is no question under the Philippine Constitution we have a mandated shared competency in the entry and conclusion of treaty and international agreement. It has to have the imprimatur of the President with the concurrence of 2/3 members of the Senate. But how about exiting or withdrawing from a treaty or international agreement? Is that power lodged in the President alone, or must it likewise require shared competency of the President and the Senate? As Senator Dillon has said, Unfortunately, in terms of an expressive statement in the Constitution, there is a lacuna, meaning an absence of any explicit provision in relation thereto. As a matter of fact, we are not alone in that predicament. Only 48 of 190 surveyed domestic constitution contains provision with an express treaty exit mechanism. What then should be the rule in the absence of an exit procedure? In the United Kingdom, in Miller versus Secretary, in the Supreme Court of the United Kingdom said that domestic legislation was necessary to complete the exit. This was likewise the case in South Africa, which attempted to exit from the Rome Statute. The Supreme Court of Africa saying, there is a glaring difficulty in accepting the process of withdrawal, that the withdrawal should not be subject to the same parliamentary process. However, in the United States, lower courts have varying decisions. Unfortunately, the U.S. Supreme Court has not made up any definitive ruling. The closest was Goldwater versus Carter, when President Carter tried to exit from the diplomatic relations with Taiwan. But the Supreme Court it said it was a political issue at the time. But a number of countries adhere to the principle that the president alone has absolute power to withdraw, without limitations and without Senate concurrence, save when there is an explicit requirement in the Constitution. This is anchored in the principle that the president is the chief executive or chief architect of a country's foreign policy, and because the executive is solely responsible to communicate for our country's foreign relations externally. There is, however, an emerging view which has been known as the acte de contraire theory. Simply stated, it posits that when a constitution requires parliamentary or legislative approval for treaties subject to ratification, it likewise, by implication, requires the consent of Parliament or the legislature to withdraw from such treaties. The application of this theory is consistent with the spirit of the 1987 Philippine Constitution for the following reasons. First, the Philippines is a republican and democratic state. Absolute power is anathema to it. Any interpretation of an ambiguous provision or an omission must not lean towards absolutism, but toward the heart of an accountable structure, check and balance among the three great powers of government. Second, any attribution of a king-like imperious power to the president does violence to the Constitution. Our Constitution even provides that no law granting a title of royalty or nobility shall be enacted, if only to emphasize that point. Third, our Constitution is replete with provisions highlighting repugnance to absolute power. For example, the veto and counter-veto mechanism of the President and Congress, the shared competency in the declaration of martial law, the shared competency in the declaration of war, and even in the amendments and revisions of our Constitution. The spirit of non-absolutism is just too glaring. Fourth, in municipal law, a treaty stands in the same footing as a statute. And that being the case, just like any other statute, a treaty's abrogation, whether express or implied, can only be made by the participation of Congress and particularly this honorable body, the Senate. That concludes my presentation, and thank you.
Thank you, Dean. The Chair acknowledges Senator Binay. We will finish with the presentation of our resource persons before we have this freewheeling discussion. Senator Tatad, sir. Thank you.
Good morning, Mr. Chairman, distinguished members of the Foreign Relations Committee. Upon the invitation of the Senate President, I'm honored and delighted to be here to contribute to the discussion before the committee. In light of President Duterte's decision to abrogate the 1999 Visiting Forces Agreement, which is an implementing arm of the Mutual Defense Treaty between the Philippines and the United States. I come as a former member of the Senate who once chaired this distinguished committee during my second term and had the privilege of manning the floor as chairman of the Committee of Rules and majority leader for 5 Senate presidents. In 1999, when the BFA was brought to the floor for our approval, the Senate President tasked me to become a special co-sponsor of the Senate Resolution of Concurrence, together with the late Senator Blas Ople, who chaired the Senate Foreign Relations Committee, and Senator Pong Biason, who is here with us, who chaired the Committee on National Defense. The Senate concurred in the ratification pursuant to Section 21, Article 7 of our Constitution, which provides, quoted earlier by other persons, no treaty or international agreement shall be valid and effective unless concurred in by at least 2/3 of all the members of the Senate. Then, as now, the provision required no explanation. It's clear no treaty or international agreement is possible without the approval of at least 16 of our 24 senators. From a layman's point of view, it is the Senate concurrence in the ratification that gives validity to a treaty. Without the Senate concurrence, there is no treaty. And there would be no treaty to abrogate. That's how my layman's ability to discern the law tells me. However, no similar constitutional provision requires the same number of senators to concur if and when the President decides to abrogate a treaty or an international agreement. Therefore, the presumption is that the President can abrogate a treaty or an international agreement all by himself without the concurrence of the Senate. The Constitution is silent on this. Whether this was a plain oversight or a deliberate act on the part of the framers of the Constitution, we have a serious constitutional lacunas, the Dean referred to earlier, constitutional lapse, which we must correct. We have to ask ourselves, was the omission deliberate? And if so, why? Is it possible to speculate that, according to international practice, treaties are not lightly entered into, nor lightly abrogated? So it probably did not become necessary for the framers to put in that necessary provision. But the surest way to correct this is to amend the Constitution. Now, we don't have the time for that. We don't have the luxury of time for that. The best we can do now is to ask the Supreme Court to help cure this constitutional defect. I'd like to believe that the court, which was able to remove an impeachable Chief Justice without going through the impeachment process, can easily provide the doctrine which the framers of our Constitution failed to put into the existing text of our fundamental law. Some have argued that the decision to abrogate the VFA is a political act and not subject to judicial review. Indeed, as no court can question the President's decision to enter into a treaty, no court can question the President's decision to abrogate one also, and that we are not prepared to do. But since he cannot have a valid treaty without Senate concurrence, he should not be able to abrogate a treaty without Senate concurrence. I think that is quite clear. The decision to abrogate is the political act which is not subject to judicial review. But the manner in which it is carried out must follow the sense of the Constitution and the rule of equity and fair play. I don't want to go to an expansive discussion of the Constitution. We don't have the time for that, and that is beyond my competence. But having said what I just said, I should like to commend the committee for its effort to take a deeper look into defense and security treaties with our most important ally in the world. I'm particularly eager to see that the abrogation of the BFA, if it's not interrupted, should lead to a new beginning in our historic relations with the United States, which has become the home of many Filipinos outside the Philippines, millions of Filipinos outside the Philippines. This would be in the best interest of both our two countries, of the whole of the Indo-Pacific, and the world. I'm sure this is one of the motivations behind these hearings, Mr. Chairman. With your consent, Mr. Chairman, I would like to say something beyond the purview of my being invited here. Now I believe is the opportune time for the Philippines and the United States to sit down together for a bilateral review of their overall relationship and determine the most desirable course for that relationship to take in this fast-changing environment. We should seize the moment. Who will make the first move? It's not for me to say. It's not easy to say. President Trump is facing an election, and President Duterte is saddled with so many critical issues beyond the reach of this committee. But perhaps a friendly third party like Japan's Prime Minister Abe can do a quiet job of trying to bring the two parties together. We need to take a broader look at our relations with the U.S. in order to go beyond the BFA question. The hearings in 1999, not 98, Mr. Secretary, 99, there was an expression of concern that the terms of the agreement were lopsided in favor of the U.S. The Senate, my colleagues at the time, insisted that we balance. We remove whatever lopsidedness there was. So the decision resulted in the adoption of VFA-2, which would give Filipino armed servicemen same rights and privileges their counterparts in the US. So it is not fair to say that we sold out. There are certainly provisions in the BFA that can be improved and should be improved, but the reality is that in negotiating treaties and concurring and the ratification, the hands of the Senate are tied up. We cannot alter one word in the basic agreement. We either concur or we reject. And this has happened in the new basis agreement which President Cory Aquino authorized to be negotiated by Raul Manglapos and Armitage after the expiration of the MBA. So this is the reality. But I think we owe Senate Minority Leader Drilon a vote of thanks for bringing this issue to the fore. The power of the President is granted, but it is not unlimited. It is not absolute. It must submit to the bounds of reason and good sense. We cannot question the patriotism of the President, but we can point out that this decision, based on the cancellation of the passport of a former colleague, Senator De La Rosa, is a serious mistake that cannot be inflicted on the history of our diplomacy or on the posterity of the Filipino people. Thank you very much, Mr. President.
Thank you, Senator Tatad. May we now hear from Senator Biazon.
Thank you, Mr. Chairman. The Philippine government served notice on February 11 this year the termination of the Visiting Forces Agreement. When I was sponsoring on the Senate floor as chairman of the Defense Committee, 1999, the Visiting Forces Agreement, for concurrence of the Senate, Admiral Blair, the commander of the Pacific Command, issued a statement in Singapore. And he said, these practices are not covered by the Mutual Defense Treaty. And so during the hearings, I raised the question to Ambassador Hubbard. I asked Mr. Ambassador, is this the position, is this the policy of the United States as regards to the conflict in the South China Sea? That indeed, Kalayaan, our small town, archipelagic town that belongs to Palawan, is not covered. But it's a town of the Philippines, not covered by the Mutual Defense Treaty. And so I said to Ambassador Hubbard, if this is the policy of the United States, I said, I am not going to vote for the VFA. And he said, I cannot answer it categorically. But after a few days, he came back and provided a copy of a note verbal to Secretary Siason. And if I may be allowed, so that we will better understand it, I will read it. Dear Mr. Secretary, says Admiral Hubbard, I was very distressed to see the headline in the May 24 edition of the Philippine Daily Inquirer regarding recent statements by the Commander-in-Chief of the U.S. Pacific Command, Admiral Dennis Blair. Although I have not seen the full text of the Admiral Blair's press conference, I am concerned that the United States policy has been seriously misconstrued by the Inquirer. As you can see, the body of the Inquirer article does not support the headline, U.S. Admiral, VFA, no security blanket. And he went further. The United States government stands by its statements in the Vance Romulo letter of January 6, 1979, which covers our obligation under the Mutual Defense Treaty in the case of an attack against the metropolitan territory of the Philippines. As well as in the case of an attack on Philippine forces in the Pacific area. Last August, he said, in response to the questions on this issue during his visit to the Philippines, the United States considered the South China Sea to be part of the Pacific area. And so therefore, the concurrence to the proposed BFA at that time passed the Philippine Senate. Now, indeed, there is not now a review for a lot of things. Number one, a review on the question, do we need the VFA? Maybe we may have to go very shortly on the history of the agreement with the United States. The Philippines entered into a treaty with the United States in 1947 for the existence of the Military Bases Agreement and the Military Assistance Pact that was addressing the threat coming from the Iron Curtain. But in 1949, when Mao Zedong took control of China, there appeared the threat from the Bemba Curtain. And so therefore, 2 years after, in 1951, we entered into the Mutual Defense Treaty. But in 1991, after the collapse of the USSR in 1989, there was a proposal from President Cory Aquino to approve a new treaty regarding the military bases. The Senate voted against a new treaty. Right now, the main issue being raised against the VFA is the issue of jurisdiction on criminal cases against U.S. personnel. Now, we have 171 days, probably, a chance to modify, because modify the VFA, because according to our Constitution, after the serving of the notice of termination, there still remains 180 days or 6 months for something to be done. So maybe when we consider these things, we can take a look at the possibility of something to be done before the end of 180 days. We still have 171 days. Okay? Now, what can be done? Maybe consider a modified or amended visiting forces agreement, if the President, of course, will allow it. I'm not going to enter anymore on the shared power, and because it's publicly known, the shared power. Unfortunately, our Constitution is silent on the issue of termination of any treaty. It is silent. And that is the reason why there is a pending case before the Supreme Court on the issue of our withdrawal from the ICC. Hanggang ngayon, hindi pa yan. And that's the raising the question, can the President unilaterally terminate a treaty? That is now a case before the Supreme Court. And the second one will be probably the issue of the visiting forces agreement. And I agree that the only way to resolve the question is through the Supreme Court. And so therefore, there will be a second case to be filed before the Supreme Court questioning the unilateral exercise of the power to terminate treaties. Pupunta ho yan sa Supreme Court. First, review. When this thing came out, I thought we need to review the reasons why we enter into in these treaties. For example, when I attended the hearings in The Hague, I was the only legislator who was present there. There were Japanese representatives, there were Vietnamese representatives, there was an Australian representative, Indonesian, etc., etc. I asked them, why are you here? This is a case for the Philippines. And they said, well, we are interested in the resolution of the issue you raised before the court. And this is, ano ba ang United Nations Convention of the Law provisions? You know? And so therefore, they said, we are interested because if you win, we win. I mean, those other countries, no? And I said, well, if we win, we win. The issue of whether you also will win is subject to bilateral and multilateral considerations of the Philippine government and your governments. For example, the Chinese members of the Diet and diplomats came to me and they asked me about what is our position relative to the sprat list. And I said, we have filed a case before the International Court, the Permanent Court of Arbitration in The Hague. And I said, but to challenge the aggressive acts of the Chinese, I said, we need to form a coalition of countries that are interested in the resolution of the problem in the disputed area, South China Sea. Because, and there are many countries that are interested in the resolution to the question. $6 trillion worth of trade and commerce passes through that channel, right? Japan is affected. Even Europe is affected. Of course, the Americas are affected, etc., etc. So I said, we have to form a coalition of nations to challenge the aggressive acts of the Chinese. No one country can do that, especially us, small nations. So, of course, I said, you have a problem. You, the Japanese, are the first to be affected by the acts of the Chinese. When the Chinese declared an defense zone, air defense zone over Senkaku Island, which is your property, I said, you already are affected. And will you address this alone? I said, have a problem with your constitution. Because your constitution does not provide for participation of the Japanese forces outside of a definite area. I said, so I asked, are you going to amend your constitution? He said, no, Mr. Senator, we will change our interpretation of our constitution. We will amend our interpretation of the constitution. 1 week after, Prime Minister Abe announced, we will change the interpretation of our Constitution. We will not amend our Constitution. Now, the question is here. There was proposed kanina the possibility of amending our Constitution to address the issue. But sabi nga ni Senator Tatad, matagal yan. And so the shortest way to do this is for people, institutions in the country, the Senate, going to Supreme Court for a final resolution of the issue on the question of can the President unilaterally abrogate a Constitution. So I would join such an effort to raise the issue to the Supreme Court. Thank you, sir.
Thank you, Senator
Thank you,
Bias.
Mr. Chairman.
Drafted naman ang petition. Okay. So just for the information of Senator Biason, the petition is currently being drafted. So can we now go to the next resource person, Professor Tayaw, and then Father Aquino, you're next. Can we be conscious of the time? Mga siguro 10 minutes. If your paper is longer, just submit the paper so that we can have a freewheeling discussion, questions from the senators. Thank you. Thank you.
Actually, Mr. Chair, each time I'm invited in the Senate, I usually consume only 3 minutes, 5 minutes max. Because, of course, I know that there are so many other resource persons who may probably shed light on the issue. I will follow through on the comments of our esteemed former senators and actually, to me, statesmen, now Senator Tatad and Senator Biazon. I'm honored to be seated beside them. My thoughts would be more on the political side and, of course, the policy side in terms of reviewing the policy that is the VFA. You know, while remaining an ally of any country, bear in mind that we become part of its circle. Their friends become our friends, and their enemies become our enemies. We'd like to look around and understand how, in this scheme of things, we figure ourselves into. And so I agree with the comment of our Dean earlier, mentioning that we'd like to compare ourselves or probably learn from how the other countries benefit from their relationship, their treaties with the U.S. and other countries. And probably learn that it might be interesting to ask why our neighbors like Indonesia, Thailand, and even Vietnam gain more out of this relationship than the Philippines. However, the government that is the executive and the Senate decides how to move forward, I simply hope, as I suggest, that we start approaching decision-making by way of systems and not just be limited with the relationship between the U.S. and the Philippines. Ever since we've been doing much of our policy making and even governance piecemeal, this is also one of the reasons why we've been approaching constitutional reforms so many times and for decades already and have not done enough really to get into it. No? Mine is, of course, mainly political, but there are so many lawyers and experts of law who, I'm sure, understand that politics plays right into the heart of lawmaking and policy making. Note also that it reflects, note and reflect how we have voted on the U.S. basis in 1991. I think this has been discussed extensively by Senators Tatad and Biason, and how it resulted too in terms of politics, economy, and the community. Our foreign relations should also be understood as a tool of the nation, if not even in continuing pursuit of nationhood. So to my mind, however we proceed, whether, at the end of the day, we might also want to reflect on current events. however big and powerful a country is, in a snap, it can go down. Look at how things are going as far as COVID-19 is. No, we've been looking so high to China. I don't know whether in place of the U.S. or not, but things are changing rather fast now, and we'd like to probably figure out how to move forward as a more independent and sovereign country, not only in name, but also in terms of policy. Yan lang, Mr. Chair.
Thank you, Professor Tayo. Father Aquino, please. Thank you, sir.
Good morning, Your Honors. I shall treat the issue before us as a matter of purely of constitutional theory, as the chair and as the panel wants it to be treated. One subject that I teach at the Graduate School of Law is legal hermeneutics. And one way of testing the plausibility of a proposition of law is to review its consequences. If we maintain the proposition that the president alone or the president has unilateral power to bring about the revocation of treaties or their denunciation, then the consequence is that he can unilaterally withdraw the Philippines from the United Nations or even from an integrated ASEAN, a consequence which would not only be disturbing but also absurd. The silence that Senator Tatad observes about the Philippine Constitution in respect to the revocation of treaties is understandable because we are, after all, heirs to the American Constitution, and the provenance of the treaty provisions of the Philippine Constitution is clearly American. The American Constitution is likewise silent. And its silence is not because it intended to confer power on the president alone, because for the first few years, in fact, for the first decades, if not centuries, of American history, cancellation of treaties was a congressional function rather than a presidential function. The first treaties to be declared null and void were declared null by Congress alone, the French-American treaties of 1778 to 1788. In 1846, when President Polk wished to revoke a treaty with Great Britain, he first served notice on Congress and requested permission from Congress to do so. In 1856, the Senate Foreign Relations Committee made the following statement very clearly: where the right to terminate a treaty at discretion is reserved in the treaty itself, such discretion resides in the President and the Senate. The whole power to bind the government by treaty is vested in the President and Senate, two-thirds of the senators present concurring. The treaty in question was created by will of the treaty-making power, and it contained a reservation by which that will should be revoked or its exercise cease on a stipulated notice. It is thus the will of the treaty-making power which is the subject of revocation, and it follows that the revocation is incident to that will. The will resides in the President and the Senate. When President Lincoln in 1864 notified Great Britain of its intention to withdraw from the Rush-Bago Convention, Congress immediately passed a joint resolution declaring Lincoln's conduct invalid until ratified or confirmed by Congress. On December 18, 1911, President Taft gave notice of his action to the Senate, informing Russia on the U.S. intention to terminate the commercial treaty with Russia. But this was only because the termination was at the instance of Congress. The Spanish position is bifurcated. The participation of the Cortes Generales is necessary in respect to those denunciations of treaties that affect the economy or the defense of the country. Thus, under Spanish constitutional law, military treaties, including the presence of foreign troops in Spain, are among the treaties that require the action of the Spanish Cortes, both for their entry into force as well as for their denunciation. Your Honors, I would like to point out the same thing that was pointed out by Dean Mel Santamaria, who is Dean in his own right, but is also one of the professors in the graduate school. So I'm also his Dean. I hope he does not mind that. In the case of Democratic Alliance versus Minister of International Relations, tried by the High Court of South Africa, the court said, where a constitutional or statutory provision confers a power to do something, that provision necessarily confers the power to undo it as well. In the context of this case, the power to bind the country to the Rome Statute is expressly conferred on Parliament. It must therefore perforce be Parliament which has the power to decide whether an international agreement ceases to bind the country. This is the statement of the so-called mirror principle articulated by Senator Drilon. I would like to end with a quotation, Senators, Your Honors, from Aaron Swan, who wrote on the Mutual Defense Treaty between the United States and Taiwan, which President Carter attempted to terminate. She says, if the Mutual Defense Treaty was both a source of domestic law and an international compact, and if, as the court concedes, only Congress can supersede a treaty as a rule of domestic law, then the President's ostensible power to terminate the Mutual Defense Treaty as an international compact is anomalous at best. In other words, because it is both a creation of Congress through the Senate and of the President cannot claim sole power to withdraw from that legal order. Prior to this hearing, Your Honor, I have compiled a series of studies on treaty termination and revocation, and if Senator Pimentel wishes, I can submit it to the committee.
Please, we are very much interested, Father Aquino. Comsec, the Father Aquino will submit. Very much, Father. Is that your presentation, Father? You're done.
On my presentation ahead of time, these are some materials I used here.
Can I ask you one question? What happened to the U.S.-Taiwan Mutual Defense Treaty? Is it in fact already terminated?
That's a very interesting question, Your Honor, because up to now, the standoff has not been resolved between the United States. And that is why the Supreme Court of the United States, as already mentioned, has no definitive statement on that yet.
Okay, so we opened the floor to discussions from senators who may want to ask questions, direct or make a statement or direct questions to our resource persons. Senator Gordon.
Yes, thank you all very much, and good morning to all the resource persons. It's admirable that we can talk here and discuss the pros and cons, although there is only one pro, and I understand why that is so. Let me just ask a question. Right now, our parliamentary situation, if I may call it that, nandito tayo sa sitwasyon na we have to, I'll speak in Tagalog so people can understand outside. Dahil yung proseso natin ay nalalagay sa alanganin. Sabi nga nila, kung makaka-enter ka ng isang agreement, pwede ka rin lumabas, lalo na shared power yung pag-enter into an agreement. Malinaw yan. At sinabi ng Constitution, kailangan 2/3 vote at Senado ang mag-ratify. So sa akin, yung sinabi nila lahat, halos, especially Dean Santa Maria, Father, and of course Senator Tadad and Senator Biazon by force of one, and of course Mr. Tayo, it really indicates that before we can even go into that, and I don't even want to go into the terms of the VFA, wala pa tayo doon, yung proseso muna, makakapasok ba tayo na ang Senado kung hindi natin haharangin muna at sabihin, we don't agree that you can unilaterally withdraw from the agreement without the Senate. In other words, kailangan we have to create a position of na we're opposing the move of the President to do so without Senate approval. And that way, we can now bring it to the Constitution, to the Supreme Court to address a constitutional issue na nagbabakbakan na itong dalawa, Senate at saka the President, the Office of the President. Would that be correct? I'd like to address that to Dean Santa Maria first.
Basta't nagbabanggaan na po talaga ang Kongreso at ang ehekutibo sa isang fundamental na issue at halang na halang ang kanilang posisyon, talaga magkakaroon ng constitutional issue. Sapagkat kung mag-decide ang Korte Suprema one way or the other, siguradong yung isa, magkakaroon ng sentimiento na nabawasan ako, I was diminished. And he will just proceed with that diminished situation, hoping na siguro through constitutional amendments or legislation, mababago. But at the same time, parang may nabasag na sa isang napaka-fundamental na prerogative ng akala ng isa'y nasa kanya.
Sir, from my standpoint, the Senate has a duty as a co-equal branch of government, as part of the Congress, and especially since directly assigned sa kanila yung ratification of treaties. So if we do not speak, our voices will be absent in this process where from the very beginning we were part of. As you said, when you declare war, the President has to go to the Senate, to the Congress, both houses. No? Lahat yan, kasama yan. The veto power, as you said, process yan. So when you start, if we keep quiet on this issue, we would be reneging on our constitutional duty as stated in Article 21, Section 7, is that if I'm correct, no? Na if we can ratify, we can also refuse the abrogation or reject the abrogation. But first, we have to create some form, and I don't want to use the word casus belli for lack of a better word, a casus belli, a misunderstanding, a constitutional misunderstanding has occurred, and that's how the Supreme Court can come in. Would that be correct, sir? Yeah, that is correct.
Meron pa akong puntong isa. Kahit na kung papaano pong magdesisyon ng Korte Suprema, I'm always of the position na Supreme Court decisions must, well, although final, must always be subject to debate.
Scrutiny,
subject to scrutiny and debate, para na nga hindi mamatay sapagkat may iba pang branches ng government na maaaring i-overturn ang Supreme Court. Yan pong nakakalimutan natin eh. Supreme Court decisions may be final, but they are always subject to critical debate and
which
scrutiny.
is the point of Senator Biazon earlier. Nagkaroon muna tayo ng mutual na military bases na nag-iba ang panahon. Nagkaroon tayo ng Mutual Defense Pact because pumasok na ngayon tatawag nating China was taken over by Mao. So it was so proximate to us, so pumayag tayo na magkaroon ng Mutual Defense Pact. I kind of like what Senator Tata referred to earlier on another part of the process. Can the Senate now look into the manner upon which, as Senator Tata said, yung manner ng pag-abrogate? You know, we do have, we should have a sense of national pride and integrity. When a president, for an example, says, I'm abrogating because my man has been denied a visa, or for that matter, parts of the membership of the Senate of the United States says, mali yung ginagawa nyo kay Leila de Lima, which prompted me to say, you're intervening in our affairs. If you want to intervene, send a lawyer to Secretary de Lima because our courts are functioning. Sa akin, any statement made by a senator not formally approved as a law is fair game. So, yung manner na napaka-frivolous or whim or caprice, ang dating sa akin ganun eh. And it really, attacks my feelings na hindi natin dapat payagan naman na ganun ang gagawin ng ating Pangulo na just because hindi nabigyan ng visa isang kaalyado niya, yun ang maging rason. And I wonder how the DFA feels about it. Was that the real reason why we're abrogating? Don't we look into that? Or is there any advice given na we made China happy, we made America sad because of this? I don't think it really applies to and we would have to go through the circumstances of need now, just as we needed the Mutual Defense Pact when China became superior when Mao Zedong became superior in China. Ngayon, ang sistema natin ngayon meron tayong mga disagreements with our Chinese neighbors. They don't even follow the arbitral ruling. They ram our ships, they ram our boats, and leave us there in the ocean. and they just take over islands. So, to my mind, ang problema natin dapat siyasatin natin maigi kung ano talaga ang rason. Hindi naman yung ganong kababaw o ganong kasidhi. And I'm, of course, talagang ganyan we have to, that is our role. What would the DFA say about that? Is that the real reason for it? O i-abrogate natin ang DFA, hindi yung VFA?
Through the chair, I hope not, Senator Gordon. Well, thanks for the question. The DFA, we don't think that we could read beyond what the President has pronounced on as to the reasons for...
You don't think you can advise the President?
We definitely have advised the President.
And what was your advice?
Secretary Locsin met with the President, I think, and Ambassador Babes Romualdez was here to make the case, but the President had already made up his mind, and it's a decision, of course, that we're bound to pursue.
And then, with the permission of the chair, I go back to the theory of absolutism espoused by Dean Santa Maria. Non-absolutism. Yeah, I'm sorry. Well, whatever. I have the point is, the whole foundation of our Constitution is against unilateral exercise of power, absolute power in one side of government or in one man. And therefore, the whole design of the Constitution is checks and balances. Dahil hindi ka naman pwedeng basta gagawin mo yan, wala na, di ba? So, I'm happy that you cited some cases in South Africa when they tried to get out from the ICC, right? And the other case that you cited was UK. And what was the issue in the UK? The exit from the Treaty of the European ICC also? European Brexit. Brexit, yeah, Brexit. Tama yan. So it has to go through Parliament. Yeah.
Yes,
Answer
yes.
to the mic, sir, for Dean.
Yes, they had to go to Parliament to get the consent of Parliament.
And because of this theory of separation of powers, yung tatlong arm will work together. Kung
Yes.
hindi umayag ang Senado sa abrogation, now the Supreme Court gets involved, so it shows the balance of and control of powers. Now it cannot be lodged in one side of the government or one man. Would that be correct, sir?
That's correct, Your Honor. And as a matter of fact, in the U.S. case of Goldwater versus Carter, up to the Court of Appeals, that was the point.
The point of Justice Powell there, and I keep quoting this, was that Powell, while agreeing that the case did not merit judicial review at the time, believed that the issue itself, the powers of the President to break treaties without congressional approval, would have been arguable had Congress issued a formal opposition through a resolution to the termination of the treaty. In other words, kailangan mag-issue kami ng formal opposition, in resolution. That's why I laud Senator Dillon, because he was quick on the draw, not recklessly, but to protect the prerogatives of the Senate.
Yes.
I would not want to see the Senate become saling pusa, in other words, sa Tagalog, no? Because that's the protection of the people.
That's correct.
That if a president runs amok, or the Senate runs or Congress runs amok, the president can always veto the Senate or veto Congress, and vice versa.
That's true.
The Senate, Congress can also override the veto, or for that matter, protest on the abrogation of the agreement. That is all, Your Honor. Thank you very
Senator
much.
Dillon wants to ask a question.
Mr. Chairman, I want to refocus on the item in the agenda, and that is proposed Senate Resolution 305, where we are asserting the sense of the Senate that our consent is needed before a treaty can be validly abrogated. So this is that is where the issue is, and that is why in the at least 20 ratifications or concurrence with the ratification, the Senate inserted a clause that the termination of such treaty should carry the concurrence of two-thirds of the Senate also. And that is found initially in the climate change treaty, Paris Agreement, and subsequently in the agreement establishing the Asian Infrastructure Bank, etc., etc. There were 20, and I have not heard any comment from the DFA on these 20. And this is now part of the ratification process that we went through. And maybe I want to hear Father Aquino, Dean of the San Beda College of Law, on this point, on the process.
Yes, Your Honor. The basic requirement for bringing a case to the Supreme Court like this is that an actual controversy should exist. So I do strongly suggest and advance the proposition that the Senate send a resolution to Malacanang expressing its sense that the President alone does not have the prerogative to withdraw from the treaty, and that the Senate's concurrence should first be obtained. And if Malacanang disregards, it's then that an actual controversy exists, and then the matter will be ripe for the Supreme Court to decide. With all due respect, Your Honor, not through declaratory relief, because the Supreme Court has no jurisdiction over declaratory relief, but through one of the prerogative writs, Your Honor.
Yes, we are aware of that rule, but this is, we can argue that this is a transcendental issue which should merit the attention of the Supreme Court, even if technically
Yes,
it
Your
should
Honor.
be with
Conceded,
the,
Your Honor.
with the lower court. So, we will address the Supreme Court in a petition for declaratory relief to define the constitutional boundaries between the Senate and the executive insofar as withdrawal from treaties are concerned. Because there are a lot of implications on the withdrawal, unilateral withdrawal, ignoring the Senate.
My only proposal, Your Honor, is that preceding the action, or maybe concurrent with the action, would be a resolution by the Senate sending its sense to Malacanang that it should be it should be sought, its concurrence should be sought in the withdrawal.
Yes, we can also do that, but also the sense of the Senate will, if adopted by the committee and the plenary, will bring to the Supreme Court the position of the Senate. And we are, since the Supreme Court is the final arbiter on issues of the Constitution, then we are just asking that please, Mr. Supreme Court, define our prerogatives, where is the boundary? That's all that we're saying. Of course, inevitably, in this discussion, the focus on the VFA is understandable, but really it's beyond the VFA. It is the issue of the authority of the Senate, especially, Sec. Bailen, that the ratification, the concurrence in the ratification that the Senate did was contained a very specific process for the withdrawal, and that is the concurrence of the Senate. So that is the situation that we have today, and if there is anything in these 20 or so concurrences, it is the sense that the sense of the Senate is that we must participate in the withdrawal process, not because of whim or caprice, but because there are policy issues. We repeat, when we withdraw from the ASEAN multilateral agreement, what are the implications? If we sustain that the President has the sole authority, can he withdraw from the UN? Can he withdraw from the UNCLOS? The consequences of this withdrawal affects many policies and domestic laws, which should prompt the participation of the Senate and the Congress, because the Congress is the policy-making body in our system of government. So it is in that regard that I would wish the committee to refocus. What is before us is a sense of the Senate resolution. Yes.
Thank you, Senator Taptan wants to react, yes.
We appreciate the remarks of Senator Drilon. And I'd like to state that it's for that reason that I tried to make a very focused presentation on this issue. I think the only issue, as far as I can see it, is that no treaty or international agreement shall be valid and effective unless concurred in by at least 2/3 of all the members of the Senate. So the BFA is a valid treaty because it was concurred in by, how many were we, Paul? 2/3 of the members of the Senate. So it is the concurrence in the ratification of any treaty that makes that treaty valid according to this constitutional provision. If you want to invalidate it, you are invalidating the concurrence of the Senate. And the executive cannot do that without consulting with or with obtaining the consent of the Senate. That is my very simple proposition. I only regret, I hope Mr. Biason here joins me in this regret, that we are unable to join the authorship of the Drilon resolution. We are no longer active members of the Senate, but we would be honored to join the petition before the Supreme Court at the proper time.
Again,
Thank you.
Senator Tatad, the petition, the intended petition in the Supreme Court is a petition for declaratory relief, which Father Aquino was also the same remedy availed of in the Goldwater case. The Goldwater case also used the route of a declaratory relief to define the functions or the powers of the Senate vis-a-vis withdrawal from treaties. So that relief has been availed of. And that is what I would like to strongly suggest to Senator Soto, who is leading the effort there. But what we would like to see is an adoption by the Senate in plenary of a position that we should be consulted in general, without any reference to any particular committee, particular treaty.
Thank you very much, Mr. President.
Yeah.
Senator Biason,
Thank you, Mr. Chairman.
after the Senator, after.
Reading the Senate resolution, proposed Senate resolution number 305, this is seeking approval from members of the Senate in the expression. But if this passes, the Senate, will it compel anybody to abide by it? No.
No, it will not. But let me finish. It will not, because it will not compel, but it brings us to the Supreme Court.
Exactly.
And let the Supreme Court decide
exactly.
on
Yes.
constitutional boundaries. But insofar as the Senate is concerned, which is a co-equal branch, we
That's
say
right.
this is our position.
That's right. But it will not, a passage of this resolution by the Senate will not compel the President. So we still have to go to the Supreme Court. And we need a
But-
final ruling.
By the way, Senator Biason, as we said in 20 of those treaties, we inserted a whereas clause,
Yes.
which basically says you cannot withdraw from this treaty
Exactly.
unless there is a concurrence of 2/3 of the Senate. That is expressed there. And that has been there for the last, I don't know how many years.
But that is not contained in the VFA.
No, because
It is
it was
not.
passed in 1999.
Yes, that is
but
correct.
the sense of the Senate will now set the general rule.
That is correct. Now, is this not going to raise a constitutional question on the validity of that provision put in the new treaties? Is this not going to be questioned too? Yes.
This particular petition, which as Senate President is planning to file, it's really
Exactly.
focused on the VFA. That's why we can expect the argument that in the Senate concurring resolution on the VFA, there is no such provision that
Yes.
Senate concurrence
Mr.
is needed.
Chairman.
That would be answered.
Mr. Chairman, the petition for declaratory relief does not necessarily and is not focused on the VFA. It is on the power of the Senate. It is a definition of
Subsequent agreement.
boundaries, not on the VFA. It is on all treaties and a definition of the powers of the President and the Senate, not the VFA only. VFA is only incidental because it demonstrates the interplay of the powers. But what we are asking the Supreme Court to rule is define for us as a political body what is our role in abrogation, and we are saying that the sense of the Senate is that we should have a role, and that this role is manifested in that provision in 20 of those treaties where we place the consent necessary.
Okay, so best not to comment yet on the petition until and unless we see it, the copy. Let me make of record the presence of Attorney Roque. Senator Gordon, si Senator Binay muna. Senator Binay wants to ask a question. Senator Binay.
Thank you, Mr. Chair. Kay Father Aquino ho, when you were discussing the 1987 Constitution, was there a discussion to include a provision that when we withdraw from a treaty, there's a need for a concurrence from the Senate?
Are you referring to the committee that was created,
Yes.
Your Honor, to study?
During the course of the discussion.
Yes, that topic did come out, and the journals of the committee will reveal that the sense of the committee at that time was that was the understanding that Senate concurrence was necessary for withdrawal.
And there was no need to write it, that provision.
We were very wary about putting it in at that time, Senator, because that was the time that the ICC issue was very much discussed, and we were afraid that we would be sending a signal, as the case had already been filed before the Supreme Court, that we were taking sides at the time. So we let it remain on the records that was our sense, that it was our understanding as a committee that Senate concurrence was necessary for withdrawal.
Thank you.
Can we have that record, Mr. Father?
Senator, I suggest that you address it to Chief Justice Puno, who was our chairman and who controls the secretariat for that. Yes, the journals of the...
Of this latest one?
Yes,
of this
Senator, the
Constitutional Commission,
19th committee. Yes, po.
No. Puno eh. Father Aquino is mentioning Puno. So,
Puno,
Puno,
the committee constituted by President Duterte to study
review,
the
yes. But as ito question ko sa iyo, Father Aquino, as a member of the 1987...
No, I was not a member, Your Honor.
You were not.
I was only in high school. Your Honor.
So it's the review. Yeah, it's the Duterte, President Duterte's commission to review the 19...
Maybe we can request the chairman.
But I was saying, Your Honor, at that time, it was already the sense of the committee that it was our understanding that Senate with concurrence was necessary for withdrawal.
So can we just request that portion be the transcript?
Transcript,
be part
yes,
of
of
the record.
we will ask from the Constitutional Commission convened by President Duterte to review the 1987 Consultative Commission. That's the correct.
Senator, the secretariat at the time was the presidential management staff.
Yes, we will ask.
Yes.
Father. Thank you for that.
Mr. Chair,
Senator
we
Binay.
can also get that records during the deliberation for the 1987 Constitution regarding this provision wherein they were discussing the concurrence of the Senate.
Yes, we will do that, Committee Secretary. I think at this point, we give Attorney Roque his chance to present his position on 305.
Well, thank you, Mr. Chairman. The invitation to appear today came very late in the afternoon yesterday, and I had to stand as a sponsor to a wedding in faraway Tanay. No? But in any case, it's a privilege to appear before you. I actually did not expect I could make it at the time that I actually arrived. Now, the issue, I understand, and I was just given a copy of 305, but the issue that I was prepared to appear before this honorable august body is whether or not Senate concurrence is necessary if we were to withdraw from the VFA. And my quick answer is this has been answered by the Supreme Court. In the case of Salonga versus Executive Secretary, where I was both a petitioner and counsel for the former Senate President Jovito Salonga. In brief, the court was very explicit. It said that the VFA was constitutional because it was an implementing agreement of a treaty, which was the Mutual Defense Treaty. And therefore, the court, although it denied our constitutional challenge on the basis of constitutionality, nonetheless upheld our contention that the Romulo-Kearney Agreement was in fact illegal as being contrary to the provisions of the VFA itself. Now, of course, the ruling of the Supreme Court that it is a mere implementing agreement is very important because we know that the language of the Constitution is that only treaties must be concurred in by the Senate. And the Supreme Court was very clear. It may not have been a treaty. It is an ordinary implementing agreement. And this was the court's way of addressing a lacune that its earlier ruling in the case of Bayan versus Zamora had. No? Because in Bayan versus Zamora, they did not squarely address, is this a treaty or an agreement? They merely said, whatever it is recognized as an international agreement by both the Philippine government and the U.S. government. And so they had, on the second occasion, where the same issue was brought to the court, they needed to address that particular issue of, is this the VFA a treaty or not?
But,
And, yes.
Professor Roque,
Yes, Your Honor.
there was no ruling as to whether or not the President can unilaterally terminate a treaty, because that was not an issue there. It was an issue as to whether or not the VFA is a treaty or not, or an executive agreement.
Well, I beg to disagree. In fact, that was what I said in oral argument. In oral argument in the court, I revived the issue of the fact that there are two provisions in the Constitution relative to Senate concurrence. One is a general rule, which is Article 721, that no treaty shall be valid and binding until concurred in by the two-thirds vote of the Senate. And another is 28, Section 25, which says that where we're talking of foreign troops and bases, then it has to be in the form of a treaty duly recognized by the other contracting party as such. And we brought up the issue again of whether or not the VFA, since it was not concurred in by the U.S. Senate, was in fact a treaty which was required to be entered into for purposes of 25 of Article 8, Section 25. And the court said it was not one. And that was why the court had to say it's a mere implementing agreement. So because this was already the second time it was brought to the court had to address that issue precisely and say that it does not require concurrence because it's an implementing agreement of a treaty, and the treaty that was duly ratified by the U.S. and the Philippine Senate was the
It does not require
mutual defense.
concurrence because it was not a treaty. But nothing in that case said that the concurrence of the Senate is not necessary in the termination.
Well, because the Constitution does not provide that Senate concurrence, Your Honor, is required whenever we are to withdraw from a treaty.
Yes, precisely. That's the legal issue that we are now debating. And the proposed Senate resolution expresses the sense of the Senate that the concurrence of the Senate in the withdrawal is needed because of the principle that the process of ratification, the process of withdrawal should reflect the process of ratification.
But it is my humble submission, Your Honor, that this may be an instance of Senate overreach. Why? Because in the very recent case of the Intellectual Property Association versus Executive Secretary, the court, in fact, said that it was actually the DFA that will determine whether or not an agreement is a treaty that would require Senate concurrence or whether or not it is a mere international agreement. And this is still pursuant to Commissioner of Customs versus Eastern Trading, defining what a treaty is, one which formulates a new national policy, whereas an agreement fills in the details of an existing national policy.
Yes, these are distinctions between an agreement and a treaty, but it has nothing to do with the power of the Senate to concur, to require the approval of the Senate in the withdrawal from the treaty. In fact, that's an open question as we debate on it today. And the 305 proposes to put across the sense of the Senate that the withdrawal from treaties would require Senate approval, and that is why we will be asking the Supreme Court to rule on this issue.
Your Honor, again, let me clarify my position. No? Perhaps the reasoning why some senators believe that Senate concurrence is necessary in any instrument that they have concurred in is because the Constitution says before it can be valid and binding, Senate concurrence is needed. This is a requirement, sine qua non, for a treaty to become more or less part of domestic law. But you see, it is not actually the process of legislation. It is only said to be a requirement for a treaty to become valid and binding. It is still not the same as a law enacted by Congress. Why? Because if it were to be exactly a law as enacted by Congress, then the House should have participated in it. The fact that the framers of the Constitution limited the role of the Senate in concurrence in order that a treaty can become valid and binding means that the role of the Senate in this regard is limited to ensuring that as a co-equal branch of government, it functions or it discharges its function to be, a co-equal branch in the exercise of equality of powers between different branches of government. No? The fact that it has not required concurrence also for withdrawal is a recognition that whether or not a treaty continues to serve the national interest is an issue now vested with the chief executive, the executive department.
Yes, Mr. Chair.
Marcos.
Yes, Mr. Chair. May I, for the benefit of the body, just remind ourselves of the Brion concurring opinion in IPAC versus Ochoa,
Yes, Your
to
Honor.
which Attorney Roque referred to. Without doubt, the President has the sole authority over the conduct of foreign affairs, and this includes negotiation, ratification, and so on of internal agreements. This is the crux. The President has full discretion, subject only to the limits found in the Constitution. Hence, when you have a lacuna legis, as is clearly the case regarding the abrogation concurrence requirement, I think that, like Attorney Roque, there is no limitation imposed by the Constitution, and hence there is no requirement for Senate concurrence. This, by the way, is the most recent jurisprudence, having come out only in July 19 of 2016, so it supersedes the past, GR number 204605, if you care to keep the citation.
Any other comments? Senator Gordon, or done?
Finally recognized. Thank you.
Oh, sorry, you were raising your hands.
I was beginning to feel forlorn. Let me just ask the body, if I may. The resolution filed by Senator Dillon a couple of years ago, several years ago, on the matter of all treaties requiring congressional Senate ratification, and if there is going to be an abrogation, wouldn't that be considered as a very clear signal already to the Supreme Court that such a thing has not been opposed, has not been contradicted? Would that be a clear signal to the court already? Is Dean Santa Maria?
I don't believe so, Your Honor. Because as I said preliminary in my statement, there is such a thing as an abuse of right. It's not the right itself, but the manner by which that right is exercised, which can be questioned. And that's why we have the extraordinary powers of the Supreme Court in the Constitution, that any one of us can question any act of any agency or instrumentality of the government, even of this Senate, if there is grave abuse of discretion.
Correct.
And even the act of the President itself. So precedents will come in and out. But precedents can always be questioned because precedents can be wrong. And that's why the sense of the Senate is so important, because this is a body that has weight, whose statement can carry the greatest weight in terms of treaty making.
And that is precisely part of the legislative powers of the Supreme Court. Would you say so?
Yes.
When they interpret and set new precedents?
Well, yeah, in a way, yes. Because, but when you come out with precedent, when you look at the law and when you look at limitations, it is not only express limitations that may be involved. There may be implied limitations granted by the law, and And the Supreme Court should be able to discern this. That's why we have new jurisprudence like what I said a while ago. It can come out, and the Supreme Court can apply it.
You're saying nothing is cast in stone depending on the circumstances of the future or the present tense.
You know, the law is a dynamic thing.
Precisely.
It cannot be frozen in time. And that's why we have the concept of due process. And whereas before we only thought of due process, substantial due process, and it developed, and we have now the procedural due process.
Due process, that's right.
So it will develop, and this is the right time for it. Whether or not, by clear implication of the law, the right to conclude a treaty, which includes the Senate, carries with it the right to participate in its abrogation.
So it is obvious that I believe that the concurrence of the Senate is required and that it is a law. And I disagree with my good friend, Attorney Roque over there, that a treaty is a law. It may not go through Congress, but it takes the form of a special legal animal because it's provided by the Constitution that it becomes a law under the Declaration of Principles that we adhere to internationally accepted principles of international law as part of the law of the land.
And one more point. The Constitution provides treaties and international agreement, a very generic phrase.
Precisely.
So it might literally include almost all agreements of the Philippines with another state. So it does not limit the two-thirds vote is not limited only to treaties. The Constitution clearly provides and other international agreements.
As I said, in the course of the deliberations here, I'm not closing the idea that we can propose revisions of the agreement should the President change his mind. But of course, the President would have to change his mind, and I don't think right now he is disposed to do that.
You know, Mr. Chairman and honorable senators, in ordinary contract law, if there is an ambiguity in a provision, what are the tools for its interpretation? One way is to look at the contemporaneous and subsequent acts of the parties. And one of the and we have that subsequent act, as Senator Drilon was pointing out. Subsequent acts in subsequent treaties, Senate providing for, if this will be abrogated, then you will have to get concurrence. And that could not, and that may not only be a sense of the Senate, but the actual interpretation of the law.
Which was my point in my first question in this round, that there is no abuse of right on the part of the Senate to assert that all treaties and agreements must be ratified, not only ratified, but will be subject to scrutiny by the Senate if it is abrogated.
Of course, yes. So,
yes.
No abuse of right at all by the Senate.
Because you interpret that. I thought you were referring to the abuse of right by the executive when he unilaterally declared it without...
well, abuse of right can go both ways.
Yes, of course.
Okay, can go both ways. In this particular case, I personally feel that there might be, or there's a great sense that there is an abuse of right. That's why in my statement, I premised the 1991 abrogation of the U.S. military bases. It was deliberately done. There were discussions. There were public debates. We were all involved. And so and the end point, the denouement, is its termination. And we feel comforted by it simply because people who want to end it were rational and very deliberative. But unlike in this case, had it not for the cancellation of the visa of Senator De La Rosa, with all due respect, this issue probably wouldn't have come out.
Those are live pictures from the Senate. The Committee on Foreign Relations there looking into the termination of the Visiting Forces Agreement. Senator Coco Pimentel earlier announced there that they are already drafting a petition to be filed at the Supreme Court to question the termination of the VFA. Senator Franklin Drilon says the petition aims to define the powers of the Senate when it comes to treaties. He also says the Senate cannot accept the sole prerogative of President Duterte to terminate the VFA. Two other former senators were there and gave their statements, both the Senator Kit Tatad, former Senator Kit Tatad, and Rodolfo Biazon were sponsors of the VFA when it was ratified in Congress during the 11th Congress. They're both saying the Constitution is silent on the termination of treaties, and they both believe that the Supreme Court can resolve the issue. An official of the Department of Foreign Affairs, Igor Bailen, meanwhile insists the termination of the VFA does not require the concurrence of the Senate. You can catch the rest of this discussion on our Facebook page. That's what's happening at this hour. I'm Ruth Cabal. Balitan comes your way at the top of the hour. Keep it here on CNN Philippines to get news you can trust.
Exercised it in an abusive way.
Okay. I hope you don't misinterpret me. Because going beyond the jurisdiction of one's power, there is a penumbra or shadow that every nuance of that abuse may come in. One is absolutely no jurisdiction at all. It is my position that that is the point. But even assuming that he has it, then there is an abuse. So I do not think that each one contradict each other. That's just my point.
So are you conceding that the president has the power to abrogate the treaty
I just told you,
without
Mr.
the Senate?
I just told you, Madam
I'm
Senator.
just reiterating, I'm a little bit unclear po.
No. I am just saying that it is not mutually exclusive. Each one may come in within the penumbra on unauthorized action.
Okay.
I hope you get me.
Okay, we leave it at that for now, but it's not entirely convincing po. Sorry.
We will just reread the transcript and try to add. I have a question to ASEC Bailen. Hypothetical lang. Philippines has bilateral treaty with country X. Country X communicates its desire to terminate its treaty with us. So, whose word do we trust that country X is now terminating its treaty with us? And then do we examine the compliance with the constitutional processes in country X before we also accept their communication that they want to terminate?
Thank you, Mr. Chair. Generally, we will look into the provisions of the bilateral agreement with country X if it complies with the termination or withdrawal of the treaty. Otherwise, we can also take a look at the relevant provisions of the Vienna Convention on the law of treaties. So it would be their foreign ministry, normally under the Vienna Convention, and in specific treaties that would be authorized to send the termination of the agreement as the VFA has done with respect to the VFA. And we normally would not look beyond the reason for that termination, but just whether or not legally complies with the termination requirements.
ASEC Bailen, in the course of your presentation, you said that the power to enter into a treaty is with the President, and therefore the power to terminate should also with the President. First question, isn't the power to have a binding treaty shared between the President and the Senate through the ratification, concurrence of the ratification process?
Yes, Your Honor.
If it is shared in that aspect, shouldn't it be a shared power also in the withdrawal?
In treaty making, Your Honor, the Constitution is express, but in the President's decision to withdraw, it is not.
Yes.
And therefore, our position is that it cannot be implied.
All right. Now, I'll ask you a very specific question. Under your theory, the President can unilaterally withdraw from the Treaty on the Law of the Sea.
Theoretically, yes.
Theoretically, yes. Why theoretically? Why? And what will happen to our assertion on the 200 economic zone?
Your Honor, the exclusive economic, even theoretically, were the President to withdraw the Philippines from the 1982 UNCLOS, with respect to the specific question of the exclusive economic zone, the exclusive economic zone that's part of customary international law under Article 38, Paragraph 1B of the Statute of the International Court of Justice. So, customary rights and duties for the Philippines exist with respect to the EZ.
But what is critical is that this is a policy issue which a policy-making body like Congress should participate in, because you cannot deny that a termination of the treaty such as UNCLOS, such as ASEAN, has very wide-ranging consequences, and it cannot be left to one man, no matter how brilliant he was or he is. It is a policy issue which two political bodies of this government must participate in, especially that the Congress is a policy-making body, and the termination of a treaty would have very serious policy consequences. Would you agree with that?
Your Honor, I would agree on the first point on the gravity, seriousness of the issue, but with respect to the specific question in the committee right now on whether or not the President could withdraw, we would stick to our position, of course, that the President can do so absent.
Understandable, Mr. President.
Thank you. So, okay, yes, well, I'd like to speak now as a professor of international law. There are matters, in fact.
That is why you were invited.
Yes. There are matters, in fact, where neither the Senate nor the President can withdraw from. And these are customary norms of international